Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
Good morning, America. Good morning, Wisconsin. Good morning, cities around our state, around our community. This is Jim Santel, Morning Cannolis here at the station WAUK, the Shaw, Waukesha. It is 5:40 a.m., 101 FM, and we're going to be taking your calls throughout the next 2 hours. That number is 844-967-2789. I am once again delighted to be with you this morning. This is our fourth show, the first month of our program. Looking forward to many more weeks in the future. This morning, an especially important discussion with you, with all of our community about major Supreme Court cases of just this past week. We're going to start that in just a moment or so, but consistent with our tradition, let me begin by talking about history today. It was in 1876, Saturday, June 25th, 1876, that our Sioux and Cheyenne Native American tribes defeated George Armstrong Custer at the Battle of Little Bighorn, 1876, June 25th. 1943, Dwight Eisenhower becomes the Supreme Allied Commander in World War II. 1950, today in 1950, North Korea attacks South Korea at the start of the Korean conflict, a conflict that, as you know, lasted until 1953. 1951, CBS became the first network to broadcast in color. 1967, the year that the Beatles released All You Need Is Love. The first time it was performed in a show called Our World. 1993 was the time that Canada elected its first woman prime minister. And after that, in 2011, New York became the sixth state in the union to legalize same-sex marriage in 2011, an issue we're going to be chatting about a little bit later on today as well. So many important dates in the history of America. Today is the 176th day of 2022. And again, we're going to be taking your calls throughout this hour and next hour. That number is 844-967-2789. During the time of our first three programs, the first three sessions of Morning Cannolis, we have been chatting and focusing an awful lot about the United States Supreme Court, the decisions that it has rendered, the decisions that it will be rendering. And today, a lot of that discussion comes to fruition as we discuss at least two and perhaps more cases that were in fact decided just this past week. One of them about 24 hours ago, another about 48 hours ago. We're going to talk about all of that as we get going here this morning. Again, inviting your comments, your questions, your observations about America and the things that are going on in our nation. Let's jump right into our discussion this morning. Yes, I know that all media stations this morning, last night, yesterday afternoon, discussing the all-important decision in Dobbs. This is the case that overrules Roe versus Wade. And we should continue that discussion this morning because it does follow on the commentary, your questions, your comments from the past several weeks when we examined what the Supreme Court would likely do based not just upon the inappropriately released opinion from Justice Alito of a number of weeks ago, but also upon the oral argument that was conducted by the Supreme Court way back in December. So we've known for many, many months that this was coming. Still, even so, to see the Supreme Court yesterday at just about this hour release an opinion that dramatically changes the landscape of how we live for women, certainly in America, and I would say for all of us in America, because its implications are plainly beyond just abortion, as significant as that is. Let's begin by talking fundamentally. Let's lay some groundwork here for what it was that the Supreme Court did and did not say yesterday. It is a sweeping opinion. There are 200 pages of material for Americans to digest. I'm going to try to attempt here a bit of a summary of that that, and then we'll go back and forth and try to delve a little bit more deeply into some specific aspects of the majority opinion, a couple of the concurrences, and also a very significant dissent from, needless to say, 3 members of the Supreme Court, predictably objecting to this major decision by the United States Supreme Court. And so we begin with Justice Samuel Alito. He is writing for majority of the Supreme Court. That's 6 members. We'll talk about how that falls out in just a moment or so. And he says that the 1973 opinion in Roe v. Wade, written at that time by Justice Harry Blackmun, January 22nd, 1973, that ruling and subsequent high court decisions, including a case called Casey in 1992, we'll chat about that as well, an opinion written principally by Justice Sandra J. O'Connor and other members of the Supreme Court, that those cases, as Justice Alito, writing from the majority, said, must be overruled. Why? He goes on to say that they were egregiously wrong and that the arguments were exceptionally weak, those were his words, and so damaging that they amounted to an abuse of judicial authority. That is what the United States Supreme Court has announced yesterday in turning back in unequivocal language. It is difficult to imagine stronger language, refuting, turning back what is just about 50 years of history, civil rights history, human rights history, rights of women and others throughout our nation, turned back yesterday morning at just about this hour by this decision in Dobbs versus Jackson Women's Health Organization coming out of Mississippi. The narrow question before the Supreme Court, of course, is whether or not the 15-week ban established by the Mississippi's Gestational Age Act is in fact constitutional, and the Supreme Court upholds that law, obviously, along the way, necessarily overturning Roe versus Wade, which would have been and remains inconsistent with that Mississippi law. And so the decision, which again, as all of us know, was leaked in early May, means that abortion rights will be rolled back in probably about half the states of our union almost immediately. We'll chat about some of the numbers there as well, with more restrictions likely to come in many, many states. Wisconsin is also dramatically impacted by what happened yesterday in our high court. For all practical purposes, most people looking at this opinion say that abortion will not be available in large swaths of the country. The decision almost certainly also means that the high court itself, as well as the lower appeals courts, the district courts, are now going to become focuses of additional litigation, challenging in both sides, from both sides, in all directions, the meaning, the import of what it was that Justice Alito, writing for the majority of the Supreme Court, said yesterday, again, turning back 49 and a half years, almost 50 years of precedent when it comes to abortion rights. I will say to you also largely privacy rights, which is also the broader implication, which we chatted about at great length in our second program a couple of weeks ago. We know that the Alito opinion yesterday was joined by Justice Clarence Thomas, again, who also wrote a concurrence. We definitely need to talk about that this morning. You recall that Justice Thomas, appointed by the first President Bush, and then also joined in by the 3 Trump appointees, and they are Justices Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. So that makes up the core of the majority opinion. And then we also have the Chief Justice, who during the course of the oral argument way back in December, plainly, unmistakably trying to find a middle ground for all of this, trying to find perhaps one member of the more conservative side of the court, so-called, that might join him in a middle view that basically would say that the Mississippi law, 15 weeks, is okay, but we're not overruling Roe versus Wade. And he talks about that in his own concurrence. He does join the majority. He does make this a 6-3 vote, but he gets there on a different basis. And so that's a significant observation in our jurisprudence today. And along the way, the Chief Justice says that while he's concurring in the judgment, the decision only with respect to the Mississippi case, he would have limited that decision to upholding only that. And as I said, not expanding this more broadly. The Chief Justice of the United States Supreme Court calls the majority opinion. He calls the majority opinion a serious jolt to the legal system. He said that both majority and the dissent, which we'll also talk about this morning, displayed, as he described it, a relentless freedom from doubt on the legal issues that I cannot share. That's the Chief Justice of the United States Supreme Court, trying once again desperately, unsuccessfully, to find a middle ground, joining the majority to overturn Roe versus Wade, supporting the Mississippi law, but nonetheless carving out his own ground for it. And then also, just to lay the groundwork this morning in our first portion of the show this morning, we have, predictably, the three justices, Justice Stephen Breyer, Justice Elena Kagan, Justice Sonia Sotomayor, all of them dissenting vigorously. Lengthy, very, very detailed dissents, vigorously opposing, objecting to this decision to overturn Roe versus Wade. They indicate along many other lines that are a part of their opinion that this decision today, this is quoting from the dissent, that young women today will come of age with fewer rights than their mothers and grandmothers. That's a line that was also repeated, invoked by the vice president just yesterday as well, reacting to the opinion in America. They went on to say, this is the disagreeing justices. The court's opinion means that from the very moment of fertilization, a woman has no right to speak of. That's what the opposing, the dissenting justices say. A state, they go on to say, can force her to bring a pregnancy to term even at the steepest personal and familial costs. And so they go on to say, with sorrow for this court, but more for the millions of American women who have today lost a fundamental constitutional protection, we dissent. Those are the broad categories of the cases, of the case itself, of the opinions issued by the various justices of the Supreme Court. And Justice Alito, again, this 78-page opinion has a 38-page appendix, leaving very little authority for the proposition that some inherent right to privacy or personal autonomy in various provisions of the Constitution. We're going to talk more about that, delve more deeply into it right after the break, encouraging also your comments and questions at 844-967-2789. Talking this morning about Dobbs versus Jackson Women's Health Organization in our first hour this morning. WAUK Radio, The Shaw, 101 FM, 540 AM.
Telling me the things you're gonna do for me. I ain't blind and I don't like what I think I see. Taking it to the street. Taking it to the street. Taking it to the street. No more need for running. I don't wanna say what you had me thinking. Just a little more of that body language. Nothing's etched in stone, Rosetta. And when we talk, I can feel the whole world stop. It's all out on the table. So tell me what you want, Rosetta. I don't wanna say what you had me thinking. Just a little more of that body language.
And we're back. This is Morning Cannolis with Jim Santel. This is Jim Santel. This is our weekend review of the important stories in law and government and the aspiration for justice in America. A special program this morning. This is our very special discussion of two major Supreme Court cases this past week. We're starting out in our first hour talking about Dobbs, the case that overrules Roe versus Wade. And then we're going to move in our second hour to the case called Bruin, coming out of New York, also the United States Supreme Court, a major case under the Second Amendment having to do with guns and the right to carry guns in public in America. That case coming out on Thursday. Dobbs issued just yesterday, about 24, maybe 25 hours ago right now. And so right before the break, we were setting the groundwork for our understanding of the Supreme Court case, this opinion written by Justice Alito, in which 5 of his fellow justices concurred, including the Chief Justice, although on different grounds. And then we're also going to chat about this dissent, which articulates and codifies what many Americans, I suspect, are also feeling this morning. Before we get to some callers, we encourage your calls at 844-967-2789. Just a bit more about the significance of what Justice Alito wrote just yesterday, released to the American population, being digested this morning and throughout this weekend, the days ahead, as we look forward to even more litigation about what this means. Writing from the majority, Justice Alito also says, We hold that the Constitution does not confer a right to abortion. He has a very literalist, textual view of this and says that the word abortion does not appear in the Constitution. Of course, it does not, as do many other rights and other privileges that the Supreme Court has traditionally recognized. He goes on to say as to what standards the court should apply in the event that a state regulation of abortion is in fact challenged. Alito said that any state regulation of abortion is presumptively valid. Any state regulation presumptively valid, and as he said, these are his words, must be sustained if there is a rational basis on which the legislature could have thought it was serving legitimate state interests. And those can include respect for and preservation of prenatal life at all stages of development. All stages of development. He goes on to say that states are entitled to regulate abortion to eliminate what he described as gruesome and barbaric medical procedures, to preserve the integrity of the medical profession, and to prevent discrimination on the basis of race, sex, or disability, including barring abortion in cases of fetal abnormality. A very sweeping opinion. It is difficult to imagine a more sweeping brushing away of Roe versus Wade, 49 and a half years, almost 50 years of tradition in America, and an affirmation that the previous cases, including Casey, were simply wrongly decided. And great analysis indicating from his view and the view of most of his concurring justice colleagues that opinion was simply wrong. Wrongly decided, wrongly based upon tradition, wrongly based upon interpretation of the Constitution. So needless to say, lots to talk about this morning. We are encouraging your comments and questions. We're going to begin this morning with Dick. Dick, we thank you for calling in. Your thoughts or questions this morning about this major change in America, Dobbs versus Jackson Women's Health Organization. Glad to have you on the air with us, Dick.
Well, after this week, I can see why the polling is at 25% for the Supreme Court. That said, I think it's become the biggest albatross around the neck of the three branches of government. And I'd sum up the whole court right now in saying that the Supreme Court bringing minority-supported laws to the majority of the country.
And Dick, I think your observation is so well taken. We know even before this opinion was issued, for many, many years, there has been a majority of Americans who embrace and understand and appreciate the right to abortion in America. And it's not simply because of the tradition. There's an awful lot of discussion in the Supreme Court case about precedent, a thing called stare decisis, and the reason why we do not overturn lightly things unless they really do previously establish a notion, a fundamental understanding that we acknowledge is wrong. Your comment, Dick, about America's understanding of its right, its reliance upon this right, I think is completely well taken. And it is significant that in the majority opinion, there is very little, if any deference. There's a tipping of the hat to it, but very little deference to this notion that America has relied upon this. Women have relied on this. Families have relied on this for almost 50 years. Justice Alito and the others seem to be able to dismiss that with great ease, candidly. It is a dramatic opinion. As you indicate, it also prompts people to wonder about the motives, if you will, the partisan nature of the Supreme Court and other things that they bring to this all-important analysis. With respect to the second case we're going to talk about this morning in the second hour, which is Bruin coming out of New York, and this opinion likewise expanding a case called Heller to provide a constitutional right for the first time in American history for all Americans to carry weapons in public, specifically as to New York, but it has some broad implications under the Second Amendment. That too, a case that is probably inconsistent with much of America's view about safety and security, certainly in the wake of our recent experiences. So Dick, I thank you very much for your comment, your observation this morning, and we appreciate your calls and taking other callers as well. 844-967-2789 here at WAUK Radio, the Shaw, Waukesha, Wisconsin. I mentioned before that in addition to this majority opinion, which is sweeping, nonetheless, consistent with my general practice of assigning reading when I'm on this broadcast and others with Dom and Mike and others during the week, it is the kind of thing that Americans should read. It's a lot. It is a lot to read, but there is an accessible language here, whether you agree with it or not. And it is the kind of thing that sensible, logical, reasonable discussion should be predicated upon. We should not be reading headlines. Let's talk about one of the other headlines coming out of this opinion, however, and in particular, a concurrence from Justice Clarence Thomas, also in the news a lot these days. Justice Clarence Thomas concurring in the result, but in a relatively brief concurrence, that is a separate writing in which he agrees with the majority but says, I come to this in from a different way. He noted that the majority found that a right to abortion, that from his perspective, was not protected by the Due Process Clause of the 14th Amendment to the Constitution, as the court had said previously in Roe. And so a lot to discuss there as well in connection with Justice Thomas's concurring opinion. We'll get back to that right after the break and the implications of what Justice Thomas tells us in the world that he would have if indeed his opinion at one point in a future America were to hold sway. We're discussing this morning Dobbs versus Women's Health Organization, coming right back right after the break.
Patience, I'm a waitlist, straight my rollie, I got time. Is you home another at decent location on a dime? Trying to talk a little. Walk in the door with an attitude, brush right off on flicker light. Diving in first in the landing, double replay on sticker line. SUTTO and Chuck and Lex, no middleman. Leaving such a good impression. Rose don't got me stressing. I don't wanna say what you had me thinking. Just a little more of that body language. Nothing's etched in stone.
This once again is Jim Santel, Morning Cannolis, talking about Roe versus Wade, talking about Casey versus Planned Parenthood, and the fact that those two cases were overruled by the United States Supreme Court this past week in this case out of Mississippi called Dobbs. Right before the break, we were chatting about Justice Thomas's concurrence, which is also getting major headlines because of the starkness and the dramatic nature of what he said, agreeing with the majority, but nonetheless writing separately to say this, that the court should reconsider a number of decisions that go fundamentally to other rights beyond just the abortion right. Significantly, just by way of introduction, in the majority opinion, Justice Alito sought to allay fears about the wide-ranging nature of the opinion, the very breadth of the language that he was articulating. And he said this, he said, to ensure that our decision is not misunderstood or mischaracterized, we emphasize that our decision concerns the constitutional right to abortion and no other right. Nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. In his concurring opinion, Justice Thomas plainly disagrees with that, or at least in the world that he would have us be. He says that the court should, in fact, undertake a review of other privacy rights premised cases. He talks about Griswold versus Connecticut. We chatted about this our second show a couple of weekends ago, 1965 decision that declared that married couples have a right to contraception. Clarence Thomas would have us review a case called Lawrence versus Texas, a 2003 case. We also chatted about this, a case that invalidated sodomy laws, making sodomy a crime and making same-sex sexual activity legal across America. Justice Thomas would have us revisit that case. And the third one is Obergefell versus Hodges, the 2015 case establishing the right of gay couples to marry. Those are the three cases that Justice Thomas would have the Supreme Court take up next under this notion that, well, if there's no longer a privacy right to abortion, these should also fall. And isn't that precisely what many people predicted? We chatted about this very issue, the cascading impact of a decision of the sort that we got just yesterday in Dobbs. And again, the Supreme Court, in its majority opinion, according to Justice Alito, is not going down that road. But the dissent by three other justices plainly says, we'll wait to see. And unlikely that there will be no litigation in those other areas. Undeniably, this opens up those issues, those avenues for attacking those equally fundamental rights, and all goes to privacy rights. We talked previously about Griswold versus Connecticut, this landmark case in which the Supreme Court said, yes, coming out of the Constitution, even though the word contraceptive is not there, the word privacy is not there, you have these penumbras of rights, and various other justices talking about the 14th Amendment, the 9th Amendment, all of them sort of emanating, suggesting you've got rights beyond the narrow language of the Constitution. That notion pretty much rejected by the Supreme Court this past week. Justice Alito articulating a fairly textual basis for his decision, finding that the word abortion does not appear, and therefore, it is not a part of our tradition, not a part of our history, not a part of our jurisprudence in America. Justice Thomas wanting to go even beyond that, even while concurring with the majority in its result, to uphold the contrary to Roe v. Wade legislation out of Louisiana, 15-week abortion ban, plainly encouraging other states down the road to do the same and opening things up. Let's talk about a couple of other concurrences there. Not a lot of attention to this one. This is Justice Kavanaugh saying, as he did during the course of the oral argument, that he feels the Constitution is neutral, neither pro-life nor pro-choice. The Constitution is neutral, he says, and this court likewise must be scrupulously neutral. The court today properly heeds the constitutional principle of judicial neutrality and returns the issue of abortion to the people and their elected representatives in the democratic process. And so, consistent with what Justice Alito was saying, Justice Kavanaugh likewise embracing that, but taking a slightly different linguistic approach, I would offer, saying that, well, we're not simply withdrawing our support, we're becoming neutral. And again, I think that is perhaps just linguistic gymnastics. And let's revisit once again Justice Roberts, who again, plainly pained by all of this, trying, as the Roberts Court, as he lends his name to this court, trying to find some middle ground upon which Roe versus Wade could be maintained, while also supporting the legislation coming out of Mississippi. He says that I am not sure that a ban on terminating a pregnancy from the moment of conception must be treated the same under the Constitution as a ban after 15 weeks. That's coming from the Chief Justice. That's significant language. A thoughtful member of the court once counseled that the difficulty of a question admonishes us to observe the wise limitations on our function and to confine ourselves to deciding only what is necessary with the disposition of the immediate case. He finally goes on to say, I would decide the question we granted review to answer whether the previously recognized abortion right bars all abortion restrictions prior to viability, such that a ban on abortions after 15 weeks of pregnancy is necessarily unlawful. The answer to that question, Chief Justice Roberts says, is no, and there is no need to go further to decide this case, taking a shot at the majority of the Supreme Court in his concurrence, nonetheless lending his vote among the 6 to overrule Roe versus Wade. We have another call on the line. This is Susan. Susan calling in. We appreciate very much your time with us this morning, Susan. Your comment, your question.
Good morning, Jim. I have a question and comment combined. I am interested in the fact that the Supreme Court now has a 25% approval rating, and probably my guess is it's going to go down. But given that the Supreme Court issues these edicts, regardless of what apparently the public opinion is, so what happens if people say, hey, you don't have any way of enforcing this. How are you going to make me do it?
Susan, again, we'll hold for your other comment, which I appreciate as well. Let me comment about that. I think this is the larger issue, right? That I don't mean to undermine or in any way minimize the huge significance of this case, and it's the things that may follow if other justices, including Justice Thomas, follow on their own plans to again drop kick privacy rights in many other areas. This is huge. The other point that you're making, Susan, I would offer is equally important. When a great majority of Americans, as you just indicated, simply do not support this, again, the Supreme Court should not be responding every day in and out to polls, but nonetheless, Supreme Court should be reflecting the life and livelihood of America in the 21st century. And when it doesn't do that, and when it is so out of sorts, as you just indicated, Susan, with what Americans think, the great concern is that we begin to say, you know what? I simply don't have to follow that. Those are people whose opinions are illegitimate. They do not reflect not only mine, but they don't reflect the opinions of a great majority of Americans, on which there can, in fact, be legitimate legal basis, right? We're not simply saying that there's our unfounded other views out there. They've been legitimate for 49 and a half, almost 50 years. The concern is the impact down the road that this has on people looking at government and saying it's legitimate and perhaps saying it is not legitimate and moving in different directions. That's when a democracy, a republic like ours, begins to dissolve. That's the other great concern, and that's why your comment, Susan, is so very important. You had another observation to make as well. Go ahead and make that as well, Susan.
Well, it seems to me that this just goes to the fact that the people who are behind us have been working on this for like 40 years, and they weren't particularly, to start with, very interested in the issue, but they figured out that there was a large number of votes that was available if they decided to latch onto them, and that's the evangelical fanatics. They have managed to put everybody together with white nationalists, with toxic masculinity issues, that none of these people seem to have anything in common, and probably wouldn't give don't care one way or another about the abortion issue. But what I'm saying is that we need to look at this in terms of where do we go from here, because
Absolutely.
they're ready for us, and we're not ready for them.
Susan, your point again, so well taken. Undeniably, this is the result of a years-long plan, a playbook, if you will, beginning with a lot of failures early on. In early years of the 70s, the 80s, the 90s, the Supreme Court and other lower courts adopting and embracing the decision in Roe versus Wade and Casey and saying, you know what, attempts even to limit access to abortion, those we turn back. All along the way, a periodic and clear, if not always successful, movement forward to this day, a playbook that we saw come to complete fruition yesterday. Your invocation, your encouragement to all of us to have a playbook to begin to move in that opposite direction. Your question about what do we do next, that's going to be the subject of our next discussion as well. That's the invocation that all Americans need to think about, a playbook for the future, knowing that this is the law right now. What happens next? We're going to talk about more of that right after the break. And Susan, thank you so much for your comments, your observations. We'll chat more about this right after the break at 847-2789. This is the Shaw WAUK Radio in Waukesha, Wisconsin. And we're back. This is Morning Cannolis with Jim Santel. The last segment of this hour, but continuing next hour as well. We're chatting in this hour about the impact, the meaning, the substance, and the long-range predictions about what happens in the wake of the Supreme Court decision just yesterday in Dobbs versus Jackson Women's Health Organization. Before the break, we were taking some calls about that future and also about what the dissenters had to say about the majority opinion. Those dissenters, of course, Justice Breyer, who will be retiring soon, leaving the bench right after the conclusion of this term, Justice Sotomayor and Justice Elena Kagan. As much as I commend the reading of the majority opinion to every one of us in America who is concerned about these privacy issues, including abortion, and I would offer that is every single American of adult age, and even those in a lower than adult age. The dissenting opinion, likewise, is a must-read. It is a must-read. Also very lengthy, taking on virtually all those things we've chatted about this morning, identifying the problems from their perspective with what Justice Alito and others have said, including the concurrences from Justice Kavanaugh and certainly from Justice Thomas as well, suggesting that we should revisit all kinds of privacy rights in the future. Along the way, you've got writing for his colleagues, Justice Sotomayor and Justice Kagan, we have Justice Breyer saying about the majority opinion, saying that the majority says that from the very moment of fertilization, a woman has no right to speak of. This is from his opinion. A state can force her to bring a pregnancy to term, even at the steepest personal and familial costs. And an abortion restriction, the majority holds, is permissible whenever rational, the lowest level of scrutiny known to the law. And that's exactly what Justice Alito said in his majority opinion. And because, as the court has often stated, protecting fetal life is rational, states will now feel free to enact all manner of restrictions. The language goes on at great length. Above all others, Justice Breyer says, women lacking financial resources will suffer from today's decision. In any event, interstate restrictions will also soon be in the offing. After this decision, some states may block women from traveling out of state to obtain abortions or even from receiving abortion medications from out of state. Some may criminalize efforts, including the provisions of information or funding to help women gain access to other states' abortion services. Most threatening of all, Justice Breyer goes on to say, no language in today's decision stops the federal government from prohibiting abortions nationwide, once again from the moment of conception and without exceptions for rape or incest. Hugely important language, hugely compelling, chilling, I would offer, in terms of his predictions about what this means down the road. We have another caller right now. We thank you so much. Kristen, thank you for calling in this morning. Your comment, your observation, your suggestion about the future of America in the wake of Dobbs.
Good morning, Jim. I think one of the major societal shifts that is going to make the fight for abortion rights different this time than it was last time is social media, the media, and the fact that women are not ashamed to talk about what's happening in their lives anymore, especially young women. So, whereas in the past, in the 40s, the 50s, and before, someone would get pregnant and then get shunted off to Auntie M's house, for 9 months and then come back after and pretend nothing happened. That's not going to happen. This is going to be completely different. And when people die of botched abortions, the coroner isn't going to write, heart attack or some lie on the death certificate. We're going to find out exactly what the carnage is going to be here. And I can only call on the media to not brush this aside,
Absolutely. We're going to get those specific accounts, right, Kristen, of what is happening out there. What is the impact of what Justice Alito wrote, not just for lawyers like me and others who engage in these academic discussions? What is happening in Wisconsin? What's happening in Waukesha? What's happening in Missouri and Oregon and Florida and Texas and all throughout our nation? Those specific events, we're going to hear about them. I'm already hearing about them this morning as some of the clinics close, right? In those states that already have these trigger laws that basically say that if Roe versus Wade is overturned, we go back to the laws that we have had in place or the ones that we recently enacted that are quite literally prohibiting women this morning and yesterday after 10 o'clock Eastern time from getting access. Precisely the kind of thing that you're talking about. That accounting of the impact of this, which is also what Justice Breyer indicates should be coming down the road. That's what you're talking about, right? That's the advocacy. Mm-hmm. That's the reason why the public needs to respond to this and let elected officials, to the extent that they can, in fact, here in Wisconsin, other places around the nation, respond knowing that their impact is not as important this is not simply overturning the language in a majority opinion, but affecting human life. Incredibly important. And Kristen, as we think about what's going on here, again, I've tried to do a little bit of my own analysis of the broad legislative impacts here. We know that there are at least nine states. My math may be a little bit faulty here, including Wisconsin, that have laws already in place. Ours from 1849 prohibiting abortion. Other states, including Wisconsin, Utah, South Dakota, Missouri, Oklahoma, Arkansas, Louisiana, Alabama, Kentucky, all of those states, including our own state right now, in place right now, those old laws, ours from 1849, back in place. Now, we have a governor, we've got an attorney general, we've got a district attorneys around the state who are saying, we're not going to enforce that. We're not going to enforce that. And they're looking at legislative responses, if possible, in the state of Wisconsin and other places to address that. We also have other states out there where there probably will be changes fairly immediately. Idaho, Wyoming, North Dakota, Texas, Mississippi, again, plainly Mississippi, Tennessee, West Virginia, all of these cases. The governor of Oklahoma this morning, likewise, again, saying that based upon the legislation that state has passed, the most pro-life, anti-abortion state in the union, describing the specter that the justices in dissent specifically describe, that is that there will be no abortion from the time of conception in Oklahoma, and prompting people to move north, other places. So those accounts you talk about, Kristen, very, very important as we go forward and try to figure out what we do next in America in the wake of Dobbs.
Yep.
And Kristen, thank you so much for your call this morning. Appreciate Kristen's call, all the other callers this morning. We're taking those calls at 844-967-2789. We're here at the Shaw, WAUK 540 AM, 101 FM. We're finishing up here this hour with a very good discussion. Appreciate the phone calls, value them tremendously, about what happened yesterday, trying to get some baseline understanding of what the United States Supreme Court said, what it didn't say, the sweeping nature of the language coming out of the Supreme Court, and the equally commendable in terms of your academic understanding of it, your intellectual appreciation of what the Supreme Court has said. All of that coming out also from the dissent and the concurrences as well from Justice Kavanaugh. Again, this neutrality position that he advocates for, and the Chief Justice Roberts, who again finding no place for a middle ground here. Again, the takeaway I think with respect to this morning is the draft opinion that we saw a number of weeks ago, horrific though that was pretty much the opinion that was in fact issued. Justice Alito is not giving any countenance, if you will, not a lot of wiggle room here. Yes, he's acknowledging that today we're deciding nothing more than abortion. We will see if that happens. But the stridency of his rejection, the completeness, the unconditional nature of his rejection of everything that the Supreme Court has done up until now, including those opinions in Casey, including the opinion by Justice Blackmun in Roe versus Wade 50 years ago, going through them with great particularity and describing how unfounded they were at the time, how unbased they are to this day, how the notion of stare decisis does not mean anything, and at least in this context, and that for that reason we are now returning to what the truth in America should be. That is really his articulation of his response to all this. And again, as we go forward, as our callers have said this morning, we need to have a playbook, right? We need to have a response to this plainly not consistent with the majority of Americans out there in both political parties. And again, I would offer to you that, as I said before, the United States Supreme Court should not be responding in a regular basis to every polling effort, but the United States Supreme Court needs to acknowledge that the Constitution is a living document, a living, breathing document, that there are penumbra rights, which the justices acknowledged in the past, and those include the right to privacy in many, many areas of our lives. We'll talk more about those right after the break, including this morning and beyond, the right to abortion. Now back to the states, including Wisconsin, other places, a patchwork quilt about to be established. We'll chat more about that in our second hour, and then move into another important case on Thursday from the Supreme Court brewing with respect to firearms in America. This is 540 AM, 101 FM. You're listening to WAUK Waukesha.
I choose me, I'm sorry. 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 a trouble man, changed by the things I do. True, but it's funny how they all remember.
And we're back. It's the top of the hour. This is Morning Cannolis with Jim Santel. I am Jim Santel. We're spending this morning talking about two very important Supreme Court cases coming out of Washington, D.C. in that high court just this past week. Most of our first hour talking about Dobbs versus Jackson Women's Health Organization, the majority opinion, the concurrences, the dissents, all sending us some sense about what our Supreme Court in very different directions has told us today about privacy rights and about the right to abortion. The upshot of the opinion yesterday from the United States Supreme Court is that the Constitution, the United States Constitution, does not, in fact, confer a right to abortion. Roe versus Wade, Casey, 1992 case had followed it. Both of those explicitly, undeniably overruled. The authority to regulate abortion now returned to the people and their elected representatives. And that's the additional comment I would make before we go to more callers this morning, which we appreciate tremendously. The invocation, the application, the invitation, if you will, to legislative response is going to go in a number of different directions. As we said before the break, many states out there have laws that are effective as of this morning that prohibit abortion in America. That is a stunning reversal of where we were even 25, 26 hours ago. Other states plainly implementing changes that will move in that direction. And significantly, there are other states out there, unknown in terms of specific numbers, but probably an equal number of those who are going down this more strident road. Other states firming up their rights to abortion, firming up the rights of women under their own constitutions, their own state statutes, to observe and to have access to reproductive rights. And so that's happening at state legislatures around the country. That's where advocacy is all important. That's the kind of thing, candidly, that at the invitation of Justice Alito, all Americans should be taking up. The other one that's out there, of course, is that this can, in fact, this decision yesterday can, in fact, and almost is underway as a legislative response. The United States House of Representatives has already codified, if you will, in some legislation, can reintroduce that legislation in future Congresses that would codify Roe versus Wade in the federal statutes. The federal statutes. Now, that would still have to pass muster, and plainly there'd be more argument among the lawyers about that. But that is a legislative response. It could also take place at the federal level. Lots of argument, lots of discussion about that option, too. Of course, the immediate concern is what happens in the Senate, and that is why the all-important vote coming up in November, the midterm elections, that are going to decide who holds control of the House and of the Senate. That also tremendously important on this issue and many others. Just as Roe versus Wade can be codified legislatively by the United States Congress, so too can other legislation, perhaps, for example, banning all abortions statewide in all states throughout the United States of America. That too could be implemented by a federal legislature, our House, our Senate, and that is why my final observation about this, before we move to at least one caller, is voting, voting, voting. Where do you get Supreme Court justices? You get them from presidents with the advice and consent of the Senate. And where do you get presidents? You get presidents by voting through the Electoral College, as we have seen most dramatically in recent days, weeks, and years. You get presidents, you get Supreme Court justices, you get elected officials who can make decisions about legislative responses to judicial orders. You get them through voting. So voting, registration here in Wisconsin, every other state in the union, every town, every village, every city, vote. All those who are eligible to do so should do so as a way of responding however you feel about yesterday's opinion. The other one we'll discuss in just a moment, having to do with guns. Voting is the all-important avenue to address those issues and to get your voice heard to the extent you feel the United States Supreme Court and perhaps even your state or federal legislature is not listening to you. Putting those people in power who do have your voice, do have your best interests in mind, the safety and security of everyone, including health care for all women in our nation, that too accomplished through voting. Joe, we're on the line. You've been waiting for a while. Would love to hear your comments, your questions this morning. Thank you so much for joining us this morning.
Thanks, Jim, and as always, I really appreciate the discussion. So I had two questions I wanted to ask, and if they have already been covered in the hour, I apologize because I came in late into your hour. So it's two questions that I would have about what is emerged from this discussion. First is, you had mentioned, and other people have mentioned, possible restrictions on interstate restrictions on travel for women that might emerge out of this decision. Oklahoma, other places that are they're taking a very strict view on this. Can you describe that, and then how that might play out, and how that might clash with? I'm stupid about this, but interstate commerce. How can women be prevented from traveling from one state to another to get an abortion in light of interstate commerce? And the second question that I would have is, many people have looked at the issue of abortion not as religious or health, but instead from the issue of bodily autonomy, meaning that no one has the right to use another person's body without that person's consent. So looking at, for example, you might need a kidney from your dad, and your dad may be the only person that can give you a kidney, and you may die if you don't get this kidney, but you can't force your dad to give you even one kidney if dad doesn't want to do it. Or the idea that we can't harvest organs from a person who has died, and those organs may be used to save lives, such as donating lungs or hearts, kidneys, but we can't force that if that person has not given consent previously. So can you respond to those two questions, the one of interstate restriction of women and the question of bodily autonomy? No one has the right to use another person's body, and how that may play out in further discussions of abortion as we go forward. Thanks a lot, Jim. I appreciate it. I'll listen for your response.
Thank you so much, Joe. And let me say at the outset, those are far from stupid questions, far from stupid observations. I would offer just the opposite. Right on target, very intelligent as always, and appreciate your bringing us to those discussion points this morning. Let's talk about the first one of those, very important, the right to travel. I don't have the exact years, but I can go back and pull out a couple of cases from the late 19th century in which the United States Supreme Court said that there is a constitutional right to travel. And now this implicates a lot of things we talked about even the first hour. The word travel does not appear explicitly in the United States Constitution. It's not there. Just like the word privacy is not there, just like the word abortion is not there, all these things that the majority of the Supreme Court today seem to be relying on to strip away this fundamental right. And so the Supreme Court, and this is still good law to this day, has said that each and every one of us has a right to travel. And yes, it's premised upon Commerce Clause and interstate movement, all those kinds of good things, Joe, that you just identified. That right is inviolate. It's not there, but it's also a part of the penumbra, maybe the 9th Amendment, maybe the 14th Amendment, other premises inside the Constitution to say you've got a right to travel. And so, Joe, to your very good question, we do have legislatures out there that even this morning, yesterday, and the days ahead are going to say, even if you are a resident of fill in the blank of your state, and you leave that state to get an abortion in a neighboring state where it is in fact illegal, you're violating the laws of your home state. The question is that kind of restriction on your travel constitutional? I would say, and I think an awful lot of people would say, absolutely not. Not to say that legislatures will not try to impose that kind of legislation, but their view that somehow you can restrict travel has got to be completely contrary, as you just indicated, Joe, to this fundamental right to travel. And we were seeing that, I suspect, exercised even this morning, yesterday afternoon, throughout the weekend and the days ahead, as women exercise that right to travel to places where abortion is still legal, where you can still have access to reproductive rights. That's got to be held inviolate. And so exactly right on point, important issue. The right to travel is as inviolate as I would say the right to privacy is. And again, even though it's been taking a big hit yesterday, I would certainly like to think that in the America that we live in, all those other penumbraed rights to privacy and other predicates for reaching that privacy, those privacy interests, those still exist, notwithstanding Justice Thomas. As to your other very good point, take a look at the dissent. from Justice Breyer, and obviously joined in by Justice Kagan and Justice Sotomayor. Joe, that's exactly the kind of thing that they're describing. Talking about autonomy, talking about all these issues, not perhaps invoking the specific examples that you've invoked about organ donation or compelling someone to give up a kidney or another organ, but the spirit, the content of what you just articulated is precisely the example that the dissenting justices articulate in saying the majority has got to be wrong. Think about all these other areas in medical care, in medical treatment, where we would never even think of imposing governmental restrictions upon the decision of an individual, women, men, frankly, the supervision of parents and other guardians, young people, boys and girls, medical decisions of all sorts that go to your autonomy, your bodily function, your bodily integrity. We would not even think of going to our major medical institutions, our research institutions, and saying, you know what, government is going to come in and tell you exactly what you can and cannot do. Those discretionary decisions have got to be made by individuals. And so, Joe, to put it very pointedly, what's the difference? What is the difference between that and what we're doing here? I would offer, and again, the dissenting justices bring this point home, there should be none. There should be no difference between those two things. And it is the argument that I would offer should be made now to those state legislatures that are considering changes in one direction or another in the wake of Dobbs. It should be the argument that we advance to our federal Congress, our House of Representatives, our Senate, in which we say, once again, decisions about health care, decisions about your body, the most private thing you can possibly do, secondary to your home, right? Decisions you make that have to do with your family, your interpersonal relations, all those kinds of things. Those have got to be held inviolate, and that has been the increasing arc of history throughout our American history as we go forward. So, Joe, appreciate the comment very, very much, and look forward to other questions and comments by other listeners at 844-967-2789. As we come back, we'll finish up this discussion and move on to the other major case of the United States Supreme Court this past week, Bruin, having to do with firearms in America at the Shaw, WAUK, 540 AM, 101 FM.
Could be different. Time that is something. And giving everything. Oh, to be a happy man. Buy yourself a dream. How's it looking? Buy yourself a car. A house to live in. Get yourself a girl. Someone different. Buy yourself a dream. No, I won't let it take or twist me. I just got told that I got approval. No, I won't let it take or twist me. I just
Back. This is Morning Cannolis with Jim Santel. This is Jim Santel. We are in our second hour this morning, moving shortly into a discussion of a second major Supreme Court case coming out of Washington, D.C. just this past week, a case called Bruin, implicating Second Amendment rights. That happening on Thursday, Dobbs happening on Friday. But before we go to that particular discussion, let's take one more caller. Jack is calling in. Jack, your comment, your question, your observation here this morning.
Yeah, thank you. First of all, I'd say this is definitely not a conservative court. In my opinion, the correct term is reactionary. Mm-hmm. At a minimum, they've set Americans' human rights back 50 years. And in Wisconsin, they've set us back about 175 years. Secondly, this is the first time in my over 70 years that I've seen the court take away human rights. It seems to me that the Founding Fathers gave America the greatest human rights that their current society could handle. And that implies they intended the exact opposite to happen, to increase the rights as society changes over time. It appears that the only right that they want to increase is the right to carry a gun. And finally, I seem to recall seeing old West movies, and I don't know if these are if they're accurate or not. But in these movies, when anyone came into town, they couldn't carry guns. The local sheriff required them to check the guns with the sheriff in order to avoid gunfights in the streets. This court, if it existed in the late 1800s, It seems they would have even declared that unconstitutional. So
Jack,
we have a pretty outrageous court.
All good observations, including your observation about language. You know, we talk about conservative, liberal justices. I think you're absolutely right that those terms sometimes are misleading, especially with respect to particular alliances and how the justices decide. Your second and third points are even more important, right? That when it comes to understanding what should be going on in America today, this Supreme Court is out of step, at least from my perspective. I suspect yours as well. And also, Jack, your comment is a great segue into our discussion about this case coming out of New York called Bruin. We discussed this matter, this litigation coming up to the United States Supreme Court in our very first show early June in this sequence, and talked about the predicates for it. We recall well that 14 years ago, in a case issued by a majority of the Supreme Court, by Antonin Scalia, a case called Heller, the United States Supreme Court said, in the first time in its history, that individuals have an individual personal right to gun ownership in their homes for self-defensive purposes. And the question for the past 14 years is, does that extend beyond the homes? We chatted about this at great length this past week, right before the decision yesterday in Dobbs. The Supreme Court issued another opinion in New York State Rifle and Pistol Association versus Kevin Bruen, Bruen. Comes out of New York, and it is premised upon a century-old act called the Sullivan Act. It placed responsibility in local law enforcement, some discretionary judgment to grant concealed carry weapons or authorizations to citizen applicants. And the significant part of that was, as we know from the litigation in Bruin and certainly the opinion issued on Thursday, was that the state law, much, Jack, as you just indicated with respect to those old Western towns, required a demonstration, this is the language of the law, a demonstration of a special need for self-protection distinguishable from that of the general community or of persons engaged in the same profession, namely a kind of a clearly stated non-speculative need for self-defense, vesting again in local authorities the decision to keep us, the discretion, the judgment, the inclination to keep us very much safe and secure on our streets by making those all-important calls. And so, again, that was out there for about 100 years. There are about 6 or 7 other states that have similar discretionary practices and policies for granting concealed carry permits, and we can chat more about that and open carry and the differences between those two things. This past Thursday, the United States Supreme Court, major Second Amendment case. I would offer it's the bookend to Dobbs in terms of what this Supreme Court is doing in America. Under the Second Amendment, found that right that was established, again, for the first time in 200 years, 14 years ago, to establish individual gun ownership in the home, now extends beyond the home. And that with respect to New York and similar regimens of oversight by government cannot take a look at, cannot analyze the specific reasons for a request, what's called a proper cause requirement. In other words, coming forward and saying, this is the reason why I want this particular gun in this particular area. Governments, local authorities, state authorities cannot invoke a proper cause requirement that it violates the Constitution. And as the Supreme Court, in this instance, a majority, once again, in the case authored by this time, by Justice Thomas, says that requirement, that proper cause approach, violates the Constitution by preventing law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment rights to keep and bear arms in public for self-defense. A huge expansion of that right under the Second Amendment. Goes on to say, this is again Justice Thomas now writing for a majority of the Supreme Court, says that the amendment, the Second Amendment, is the very product of an interest balancing by the people. In other words, you don't have to have local authorities, you don't have to people contemporaneously looking at these things. The Second Amendment, by its very nature, establishes your right, if you, in fact, you abide by maybe certain procedural administrative processes. It establishes that right in the very text, the very language of the Second Amendment, and it surely elevates this above all other interests the right of law-abiding, responsible citizens to use arms for self-defense. That's the United States Supreme Court, again, on Thursday of this week. An opinion, again, following up on Dick Heller and Justice Scalia in this case called Bruin, a very, very significant case. The majority opinion, again, authored by Justice Thomas, joined in by Chief Justice Roberts, Justices Alito, Gorsuch, Kavanaugh, and Barrett. The Second Amendment right to carry arms in public for self-defense is no different and is also supported by history. A huge amount of attention in that case to the text, once again, of the Second Amendment, to history, and also taken by the dissent, which we'll talk about right after the break, to contest this finding that Second Amendment rights should be broadened even more than they are into the public domain. We'll chat more about that right after the break. Jack, we appreciate your call as always, and we're taking more phone calls here at WAUK 540 AM, 101 FM right after the break here at the Shaw in Waukesha.
I'm alright, but I still resent you. I'm alright, I don't know what else to say. I'm alright, and I know without you, I will surely be okay.
And we're back. This is Jim Santel. We're chatting this morning about major Supreme Court cases of just the past 48 hours, including Dobbs at the start of the program this morning. And now we're chatting about Bruin, this Second Amendment case coming out on Thursday that expands dramatically our understanding of the Supreme Court's understanding and therefore understanding of what the Second Amendment does and does not mean in America. I don't need to tell anybody listening this morning about the significance of the horror, the catastrophe, the destruction that firearms in America are causing to our population. Recent reliable statistics, over 7,300 interpersonal firearms deaths to date this year alone in 2022. That does not include law enforcement deaths, defensive firearms uses, unintentional shootings. Over 300 people killed in mass shootings, meaning a shooting involving death or injury involving 4 or more people. Those are stunning statistics in America and underscoring once again our need desperately to address our firearms problem, our challenge in America. In the midst of that, the United States Supreme Court on Thursday issues this opinion expanding Second Amendment rights, admittedly probably impacting most directly New York and a few other states out there that have these so-called may issue discretionary licensing processes, but along the way, some fairly broad language about what the Second Amendment means in America today. That language authored this time in the majority by Justice Thomas, joined in by the Chief Justice and others. The Chief Justice and Brett Kavanaugh, another justice on the Supreme Court, also issue some very important concurrences. In other words, they're agreeing with the result, again, a 6-3 result to expand this understanding of the Supreme Court to take it beyond just the home into public places, presumably secure places, but nonetheless public places. But both Justice Kavanaugh and the Chief Justice underscore the fact that there's a distinction between these discretionary may-issue licensing regimes that New York has and other states do not, and the so-called shall-issue states where, for example, the process is simply administrative, getting some training, filling out a form, maybe filing a fee, those kinds of things where you don't have to do a kind of a good cause showing, a proper cause showing. They make that distinction, which perhaps gives us a little bit of solace about the impact of this Second Amendment ruling. I would offer that even more important than that, and take a look at their concurring opinions. Both Justice Kavanaugh and Chief Justice Roberts underscore once again this all-important language that we chatted about the very first show of our program here in June, Morning Cannolis. We talked about this language. What does Heller say? Nothing about the Supreme Court cases, including this one this past week in Bruin, including 14 years ago in Heller, restricts the capacity of responsible, reasonable elected officials, appointed officials, to impose, to establish, to create reasonable, rational restrictions, conditions, understandings about all sorts of things related to firearms. That's in Heller, and that is repeated by the United States Supreme Court, at least with respect to these two justices in Bruin. What does that say? Reasonable, rational restrictions and conditions on everything from the manufacture, the transfer, the sale, the ownership, the operation, the use, the carry of firearms, all those kinds of things can be subject to rational, reasonable limitations by legislatures, and that's what we need to go forward on. Interestingly, this time concurring also Justice Alito saying that the holding in Bruin, again, expanding the understanding of the Second Amendment beyond the home into public venues, nothing about that restricts in any way the capacity of legislatures to do just that, to impose reasonable restrictions that may be imposed on the possession or carrying of guns. That's Justice Alito speaking again 48 hours ago. Likewise, Amy Coney Barrett takes sort of an academic shot, if you will, a little bit at the majority, with which she otherwise confers, and says the court is careful to caution against giving post-enactment history, that is the recent legislation, more weight than it can rightly bear. And so what she's saying there is this focus on history, this focus that Justice Thomas and the other justices advocate for, and this focus on text need to be understood in broader contexts as well. So all of that very good language in the midst of a very, very broad statement by the majority of the Supreme Court, again, adopting a very textual approach to the Second Amendment and focusing a huge amount on history. And that brings me to the dissents, which, again, we've got the same three. Again, Justice Breyer, probably anticipating his departure from the court, writes a second major dissent in this case called Bruin. He once again is joined by his colleagues, Justice Sotomayor, Justice Kagan, just as they did in the abortion case, Dobbs. And he says that cataloging and describing the recent catastrophic history of Americans' gun violence should basically tell us all the things we need to know. He invokes those same statutes that I talked about just a few moments ago from the CDC and from other authorities, talking about what's going on today in America. Again, once again, making the Constitution living and real, a breathing document today. And he describes the majority opinion as failing to consider the deadly consequences of its decision. He also goes on to say that, you know what, it's entirely appropriate for the courts to review reasonable, rational limitations on guns based upon rational, reasonable purposes for government. And what are those purposes? Safety and security, right? Keeping us all safe and secure, keeping us healthy. And he says that analysis is the one that should hold, not this overly wrought focus on history and on text. He does, for what it's worth, go back along with his associate justices, Sotomayor and Kagan, and takes on Justice Thomas in all these areas: the colonial area, the early days of our nation, the 19th century, the 20th century, and he describes in his codification, I would offer a more accurate codification of history, all it is that he sees in that history that supports a much more limited understanding of the Second Amendment. He plainly would not embrace the broader articulation of the Second Amendment that the full court today, yesterday, the day before, has embraced and deposited into our jurisprudence. Goes on to say that I fear that it will often prove difficult to identify analogous technological and social problems from medieval England, the founding era, or the time period in which the 14th Amendment was ratified. Laws addressing things, including ancient weapons, will be of little help to courts confronting modern problems. Again, that is a straight shot at the majority saying, this focus you have on the history and not thinking about what America is confronting today, that's wrong. And simply going back to the past is not going to provide courts, lower courts, appellate courts, even a future Supreme Court, a sufficient basis upon which to decide future cases. And again, here's the language of the dissent. The history, our American history, they say, seems to establish a robust tradition, this is the dissent, of regulations restricting the public carriage of concealed firearms to the extent that any uncertainty remains. That uncertainty counsels against relying on history alone. Again, taking on the majority, saying, no, you cannot simply focus on history. That does not give you proper judicial guidance for the present and the future. And finally, to the same point, this wonderful, lofty language coming from the dissent. Admittedly, this is not the language of the majority. This is not the law in the Supreme Court today. But nonetheless, listen to the language. It is appropriate to look beyond history and engage in what the court calls means and scrutiny. That is, finding out what the end is to keep us safe and secure and determining whether the government, a local government, a state government, has invoked some rational means of getting us there. Means and scrutiny. Courts must be permitted, the dissenters say, to consider the state's interest in preventing gun violence, the effectiveness of the contested law in achieving that interest, the degree to which the law burdens the Second Amendment right, and, if appropriate, any less restrictive alternatives. That's in the dissent, joined in by two other justices, written by Justice Breyer as he begins to look to his last days on the court. A major, major case. Again, in about 6 or 7 other states beyond New York, this will continue to be significant, but we will look to more of that and a greater understanding of exactly what Bruin means. And we'll talk about our next programs right after the break here in the Shaw. This is Morning Cannolis with Jim Santel, taking your phone calls also at 844-967-2789. And we're back. This is Jim Santel, Morning Cannolis, chatting this morning about 2 major Supreme Court cases, Dobbs having to do with abortion rights, Bruin having to do with firearms rights in America. Also taking your phone calls. And as we go into our final minutes here, we're also taking a phone call from Mark. Mark, glad you're calling in. What's your comment or thought this morning?
Yeah, I'm kind of horrified by both the decisions. Even though I'm a gun owner, I don't feel the need to, pack everywhere, because that was not good for the Old West. And I mean, that I don't know what these guys are thinking that it's going to actually improve safety on the street, because I just don't see that happening. For the abortion thing, I think that's just tragic that they failed to recognize how our society is involved and how opinions have changed on that. But one thing that gets me is the complete, that these guys, that these strict traditionalists on the Supreme Court, that they fail to recognize the warnings our founders gave us about, the potential for bribery of judges and such, because they've abandoned the code of ethics. I mean, here in the state of Wisconsin, they have somebody who's likely to be either a defendant or a plaintiff on the Supreme, before the Supreme Court, writing the code of ethics for that court, and are, that for the whole recusal,
right,
rules that they used to follow are just simply not followed anymore. Because Clarence Thomas should certainly be recusing himself from some of these cases but he simply doesn't. And Amy Coney Barrett, I mean, that it is just sad that they think, that they're high and mighty judges, but they're going like they're anointed by God, like the judges we had under the kings. That it was their way, and what they did was coming from that divinely ordained. And in this country, we the people ordain our magistrates. I mean that.
Right. And they come, as I said before, through the elective process, right? These are appointed, but many of our judges and justices, including right here in Wisconsin, are elected. And I just want to underscore the importance not only of your first points about Dobbs and Bruen. I concur in that. And again, changing dramatically our life here. But beyond that, your very important point, Mark, about the importance of having respect for our judiciary. A previous caller talked about that as well. And when there are reasons to doubt the impartiality, the things that justices should bring and should not bring to their decisions, that tends to undermine everything that happens after that. And so this ethics issue that you raise, with respect to certainly Justice Thomas, but frankly to every judge, every justice out there who should not be deciding cases in which they have a personal, marital interest, financial interest, those kinds of things, by ensuring that those are enforced, what do? You also give more legitimacy to people looking at the court and saying when they do in fact issue opinions, even ones with which I do not concur, I will still observe those, I will follow those, and I respect those. When those ethics issues, Mark, that you talk about are not in fact advanced, and I have to believe that Justice Roberts right now, among other things, is taking a very close look, and hopefully at some point soon will be telling us more about the rules as with respect to his own colleagues on the Supreme Court. Those kinds of things have got to be observed, and again, adding more legitimacy to our courts, even in times, as you indicated, Mark, when we have reason, you and others, reason to suspect the motives and the legitimacy of those opinions coming forward. So, Mark, we appreciate your comment this morning. We're going into our final moments here. A few other observations today about what we have talked about, and looking forward in particular. This past week was these were not the only cases decided. A handful of other cases of frankly, maybe not the dramatic impact, but very important to the litigants involved, very important to other areas of the law. And I wanted to indicate that beyond what we have talked about today, next week, we're going to be spending some time chatting about the entire term. Why? Because the Supreme Court, in the wake of its issuance of Dobbs and Bruen and this handful of other cases just this past week and in previous weeks, has indicated that on Monday the 27th, 2 days from now, it's going to be issuing more opinions coming out. By my math, and again, my arithmetic may not be perfect, but my math is that there are 7 more cases to be issued yet. And again, they may not fall at the high levels of Bruen and Dobbs, but they should, if you will. Let me identify once again, as we did at the last show, 3 of those 7, and perhaps chat about some of those in particular. We've got other issues related to religion and immigration, and also the environment. What are those cases? You've got a case called West Virginia versus EPA. Has to do with the EPA rulemaking authority for greenhouse gases. We chatted last time about the disagreements between the Trump administration, the Obama administration, the Biden administration, in this very important area of executive authority to make decisions about environment at a time when we're all concerned about climate change. The Supreme Court's going to tell us, presumably maybe as soon as Monday, what the executive can and cannot do. A hugely important case. We've got another case involving prayer, school prayer. It's Kennedy versus Bremerton School District out of Seattle. Question about whether or not a coach who has been praying after football games in the 50-yard line, whether that kind of religious exercise is indeed protected by the First Amendment, or whether the Establishment Clause, also of the First Amendment, enables the authorities there, the school district, to say, you know what, that kind of very public prayer, also involving all members of the football team on the field itself in a very public arena, that violates and impinges upon the Establishment Clause, and we're establishing religion by permitting you to do that. A very, very important issue, a very important analog to another case that they decided just this week, coming out named Carson versus Macon. We'll chat about that, also having to do with Maine. So you've got already an environmental case. You've got this religious case also coming up, perhaps as soon as Monday. And then there's also the so-called Remain in Mexico case, and this immigration case, specifically environmental issues, also going to be decided by the United States Supreme Court perhaps as soon as Monday, having to do with whether or not the Remain in Mexico policy put in place by the Trump administration, an attempt to rescind that, to overturn that, formerly called the Migrant Protection Protocols, overturn that, reverse that, so that asylum seekers can, in fact, remain in the United States while their asylum applications are pending. Who has the authority to do that, and what is the right decision there? The United States Supreme Court, probably on Monday or maybe later in the week, if they decide to add yet another opinion day, will be deciding those cases: immigration, religion, and environment. Very, very important cases. And yes, there are 4 others out there having to do with war powers, having to do with sentencing under the First Step Act, having to do with a jurisdiction of the courts in some due process issues, and also sentencing for doctors prescribing prescriptions in America. So 4 other cases that may not seem as important as they may appear just in that very, very overstated and very expansive description of them, but also coming out 7 more cases yet to be heard by the United States Supreme Court, yet to be decided by the court, probably as soon as Monday of this coming week. And so the upshot of all of this is that we do have a court in the mid part of our year of June of 2022 that is going to be ending its term very, very soon. Justice Breyer is going to be resigning from the court. Once all of these cases have been decided, we know well that Justice Ketanji Brown Jackson then is going to be formally sworn in to take his place on the court. Will probably not be affecting, almost certainly not affecting the balance, if you will. We talked today about this 6-3 majority with respect to both Dobbs and Bruen. That is not likely to be affected by her replacement of Justice Breyer on the court. But nonetheless, an arrival in October of a new justice is going to change the composition and presumably some of the deliberation on the Supreme Court. We look forward to Justice Ketanji Brown Jackson's entrance onto the court and her involvement in the discussions that do in fact take place on issues like the environment, like immigration, like religion, and yes, also privacy rights and gun rights, abortion rights in America. All those things coming up. A reason, once again, to continue to be focused on all of this and to underscore once again the point that I made a number of times today. To the extent that we are concerned about issues before the United States Supreme Court, and specifically the decisions, the resolutions of those issues that are being made on a regular basis. What is the solution? In part, absolutely. The things that we're seeing right now in America, this very hour, as people are now coming out of their work week and identifying the things we've talked about this morning, taking to the streets in peaceful protest of what government, this particular branch of government, has done. There are protests in both directions, as we've seen on Capitol Hill, right in front of the United States Supreme Court, right here in Wisconsin and other states throughout the union on these cases. That is appropriate. Also appropriate to advocate to our legislatures as we go forward. There is a role to play for the legislature. There's a very important role to play for executives as well, governors, presidents, others in appointed positions in the executive branch who are all important when it comes to our understanding and the things we want seen in our nation as we continue to address issues related to our safety, our security, and our well-being. It continues to be my great pleasure. I want to once again thank Mike Crute and the entire team here at WAUK The Shaw for giving me this opportunity to spend some time with you every Saturday morning from 9 to 11, chatting with you about the important issues in government, in politics, in law, and the aspiration for justice in America. We will continue this again next Saturday, continuing to take your questions, your comments. In the meantime, be well, be safe, and as a part of our general commission to the future, let us be a part of our government. Let's ensure that our voices are heard at all levels, local, state, and federal, in all branches of government. This is Jim Santel, Morning Cannolis. Thank you once again for joining me today. Looking forward to your discussion and your engagement next week as well. Take care, everybody.